Mic check. Mic check.
Check, check.
तो पैर थोड़ा अंदर जाएगा उधर तो हो जाएगा. Hello guys, everybody settle down fast.
Hello, check. Hello, check. Hello, hello, hello. Yes, hello, hello, check, hello. Hello, check, check, check.
शिक्षा और पढ़ने को मिलता है।
We'll all stand on it.
Volunteers will be all.
And input D is for the respondent. J is for the petitioner, and D is for the respondent.
This is the council appearing on behalf of the petitioners. The petitioners are the tribal people of the Maroka community, and we are represented by the civil rights advocates. If I may have the liberty of the bench, I would like to proceed with the statement of jurisdiction. Much obliged. Whether the petitioners have approached this honorable court under Article 226, exercising its extraordinary jurisdiction. Under this jurisdiction, the High Court, the Honorable High Court, is sufficiently empowered to try and adjudicate upon this matter. If I may further proceed, I would like to state the facts. Much obliged, my friends. What is the issue of the case that emanates and forms to the cause of action of the present petition arises when the state of Varuna auctioned a mining lease, a 20-year-old mining lease in favor of the respondents, which is a private limited company. My lords, when the environmental clearances were being granted for the said mining lease, there are 4 stages for this environmental clearance: screening, scoping, public consultation, and appraisal. My lords, the public consultation that was conducted for this procedure was a sham and a mockery of justice. It was just a purported public hearing on the paper. Furthermore, my lords, the findings and recommendations of the expert assessment committee dealt with severe procedural infirmities and regarded the consent of Gram Sabha as non-essential, which is in blatant contravention with what the Supreme Court of Aurelia has said in their settled dictums. My lords, moving further, being aggrieved with this said hearing, the petitioners in the month of September 2024 had approached the Honorable NGT with regards to the grievances that occurred and emanated from the said statutory public hearing. However, that case met an unfortunate fate and was dismissed on the grounds of prematurity. Thereafter, on 1st January 2025, the proponents of the projects were granted with their final environmental clearances, and they began their site clearances. They began resettlement and rehabilitation of tribal people against their consent. With this, my lords, we approached this honorable court, and this honorable court was gracious enough to grant prayer B of my present petition. And an interim injunction was granted, and the operations of the mining proponent were stayed. With this regards, my lord, this case is now the final adjudication. And if my lords grant me the liberty, I would like to state the issues of the case.
Yes.
Much obliged. My lords, to assess this question, there were 3 essential issues raised. Issue 1 with regards to the maintainability of this petition given before the proceedings initiated before the learned tribunal. Issue 2 regards the premature dismissal of the learned tribunal, and issue 3 regards to the various violations and transgressions of the EIA notification, PESA, FERA, and constitutional actions. My lords, I will be dealing with issue number 1 and 2, and counsel will be dealing with issue number 3. If I have your liberty, my lords, I would like to proceed with my arguments with regards to issue 1. Much obliged, my lords. Yes, ma'am. Issue 1 regards with the maintainability, especially given to the fact that earlier proceedings were initiated before the learned tribunal. My lords, my case in this present petition is that this honorable court has sufficient jurisdiction to try my petition. This petition is maintainable. Given to the earlier proceedings initiated before the learned tribunal, I will be raising 2 major limbs of my arguments. First is the distinct and distinguished cause of action, and second is the exclusive jurisdiction vested under this honorable court. My lords, as earlier reiterated in the factual matrix, the reason the cause of action before the learned tribunal was a grievance regarding the public hearing. Further, the post-dismissal factual matrix, there were recent developments that have empowered this cause of action that substantiates the maintainability before this honorable court. My lords, after the said hearing was concluded, on the basis of the said consultation, the infirmities of the said public hearing will be covered by me in my following submissions in issue number 2. However, after the said dismissal, the respondents, the proponents were granted the final environmental clearances, and they started with their mining activities, which are violative of our fundamental rights. My lords, the reason at this stage that we cannot approach the NGT,
Which is that fundamental right?
my lords, namely Article 21, which is the right to life, and held time and again by the Honorable Supreme Court, NGT, and the various high courts, that NGT Article 21 is coupled with the right to environment. And further, my lords, Article 25, which is right to profess your religion, because the said hill, the Dharmina, which is the land granted under this project, is considered as a sacred site of their deities.
What details are these?
My lords, these are the local deities of the Marohi tribe, and they emanate from a Tankikota plant.
Yeah.
My lords, in this present case, there are violations of certain statutes, namely PESA, which is an extension of panchayats to scheduled areas. This entire region, along with this community, is notified and recorded as a scheduled tribe and a scheduled land. Apart from this violation, there is another statute involved, which is FRA, Forest Right Act 2006. While it's owing to these two factors, it is my case that whenever there is multiplicity of law, the NGT cannot exercise its jurisdiction. Hence, we do not have an alternative remedy in this particular case. As my lords will see on page number 13 of my memorial, there is a victim of Supreme Court of Aurelia, which I mentioned in the case of Arca Energy versus Tamil Nadu Pollution Control Board. Maharaj, if I may read what it says. Since the order impugned is combined under the Water Act and the Air Act, therefore the remedy of the appellant is by way of writ petition in the view of paragraphs 36 and 46 of judgment of this court in Tamil Nadu State Pollution Control Board versus Sterlite Industries. My lords, this victim clarifies that whenever there are multiplicity of laws, especially laws which are not mentioned in Schedule 1 of Section 14 of NGT Act, which determines the jurisdiction of the NGT, in that way, we do not have any other option but to approach this honorable court. Further, my lord, my second submission would be the exclusive jurisdiction vested under this honorable court. To substantiate this point, I would first place my reliance over a landmark authority dealing with this conflict, which is L. Chandra Kumar versus Union of India. My lords, the said precedent states that Article 226 and 32 is a part of basic structure doctrine and cannot be altered by any legislation. My lords, the vehement expression of this precedent was such that to an extent Article 323A, 323B were also struck down. Further, my lords, this 1997 precedent was reiterated and recited by the Honorable Supreme Court in year 2022 in the case of Madhya Pradesh High Court, Advocates Bar and Union of India. My lords, will also find both of these reproductions on page number 14 of my memorial. My lords, just to read a dictum, a para, what it says. In consequence of the above analysis, our conclusions are: National Green Tribunal under Section 14 and 22 of the Act does not ask the High Court's jurisdiction under Article 226 and 227, as the same is the part of the basic structure law. Whereas what was laid down under L. Chandra Kumar was reiterated and recited, reaffirmed in this particular issue, which dates to 2022. With this regard, my lords, I would like to conclude my argument, saying that petitioners have rightly approached this forum, and the learned tribunal does not have any jurisdiction to try and maintain my petition.
What if we send you back to the tribunal?
My lords, the remedy sought under the present petition cannot be possibly granted by the tribunals.
Why?
My lords, we have sought remedies which are of writ in nature, and particularly there is a prayer which states that the mining lease has to be struck down, not the environmental clearance, the mining lease granted by the court itself, the state of Corona itself. Whereas in that case, that certain enactment and the certain gravamen falls under the purview of MMDR Act. It is enactment which is not specified under Schedule 1 of the NGT Act. Hence, my lord, going back to the NGT would not have the requisite jurisdiction to try this case.
Yeah.
If my lords are satisfied with issue number 1, I would like to proceed.
We are not in move to the next.
Did you work with my lords?
We'll go to the next one.
Issue 2. My lords, issue 2 deals with whether the prior dismissal of the erstwhile community plea raised before the NGT on the grounds of prematurity was legally justified or not. My lords, with this regard, the answer in a nutshell, the long and short of the matter is no, my lords. The dismissal as premature was not legally or justified. And with this regard, we seek a writ of declaration.
This will be said if we send you back because of their premature, we send you out. Send you back to them.
My lords, at then point of time, they could have adjudicated the matter because it emanated from a EIA notification, which comes from the Environmental Protection Act, a statute specifically mentioned under the Schedule 1. However, now the post-dismissal developments of the case have locked this door for us, and we cannot possibly go back to the limit tribunal. But assessing this,
So direct you can go back.
Malaj,
Yeah, but what?
Malaj having no issue 2 is a retrospective analysis of the premature dismissal of the said tribunal. And with this regard, my lords, I have 3 points to concur. Firstly, the absence of public participation. Secondly, the arbitrary linguistic barriers. My lords, these two are the most important essentials and prerequisites of any public consultation which takes place under the EIA notification. My lords, if you may come to page number 16 of my written submissions,
Yes.
we have computed a ratio of public participation which is pertinent to be noted over here. My lords, under the provisions of Appendix 4 of the said notification, Clause 1 of the appendix reproduced there says that the public hearing shall be arranged in a systematic time-bound manner and transparent, ensuring widest public participation at the project site or in its close proximity. My lords, in the present, it says that they are intending to provide 15,000 prospective jobs. Now, my lords, for the sake of argument, let us assume that this is the number of the people being affected. However, the actual number is twice or thrice this figure. Due to constraints of facts, let us assume these job takers are the people of entire population affected. My lords, out of these, only 20 people were allowed to speak here. My lords, 15,000 plus 20 people equates to 0.133% of total public participation that was used.
15,000 will have to speak.
No, my lords, but owing to the words of the legislation over here, widest public participation, this ratio of 0.133% or allowing 20 people to speak is not even remotely close to that legislative intent, my lords. And particularly, I may bring it to the court's notice that these weren't the only 20 people willing to speak. These were the only 20 people who were allowed. Rest of them were constrained, were denied of the said public participation.
Where do you get that? Where are those facts that say they were denied?
My lords, may come to paragraph number 11 of the Moot proposition, the factual matrix.
Yes, there are 11.
Para 11, my lords. My lords, during the public hearing, a heavy police presence constrained entry to the venue and limited participation. Only 20 citizens were permitted to speak. 15 villagers opposed the project. My lords, the words over here says constrained entry to the venue and limited participation.
Yeah.
Further, my lords, there is a notable precedent by the LGT that my lords will find on page number 17 of my written submissions. Well, in the case of Kanhaiya Ram Patel versus Union of India, the NGT has held that dismissal of public participation and absence of public participation standalone can be a sufficient ground to challenge those hearings. My lords, if I may just read a dictum of the NGT. In our view, this has vitiated the proceedings. In the entirety of the facts and discussion made above, we find that in the present case, public hearing has not been conducted in accordance with law, satisfying the words and spirit of the requirement of public consultation in proceedings, as such as to deprive the affected people fair, impartial, unbiased, and valid public hearing. My lords, this also violates the second principle of natural justice, which is body ultra mortem. And moving to the second and the most important ground of this would be arbitrary linguistic barriers. My lords, the facts of the case particularly paragraph number 8 of the Moot proposition, discloses that Marohi people of the Takikota Plateau predominantly communicate in Marohi language and possess limited literacy in the official languages. They were neither notified nor consulted regarding the options and their allied consequences. The abrupt entry of Hydrina contractors, trucks, and service teams onto the community's sacred land triggered widespread alarm. My lords, under a prerequisite of the aforementioned appendix, a copy of this entire public hearing, a summary report, has to be attached in the local and the vernacular language. However, in this case, it was only attached in English. Post the consultation of the post the conduction of the public hearing, there were no official minutes of the meeting that were disclosed to these people. Further, my lords, there is another incident that I would like to invite your kind attention to. On page number 17 itself of my written submissions, in the case of Adivasi Mazdoor Kisan Ekta Samyutin, the NGT again has noted these prerequisites. This is not a case where there are few ignorable procedural lapses in conducting the public hearing. This is a case of a mockery of public hearing, which is one of the essential part of the decision-making process. In the grant of environmental clearance, this is a classic example of violations of rules and principles of natural justice to its will. Therefore, we consider it appropriate to declare that the public hearing conducted in the case is nullity in the eyes of law and therefore is invalid. Further, my lords, concluding this issue, I would like to bring it to the court's attention that NGT priorly under section 20 of the Act, which embodies the precautionary principle, owing to the application of this principle, has annulled such hearings midway in this mid-procedure, noting the fact that even if they are allowed to go ahead, they won't bear any fruits. Hence, my lord, in my view, this is my submission, that the premature dismissal at then point of time by the NGT was illegal. My lord, I would like to invite my co-counsel to further continue with issue number 3.
What are your prayers?
Maharaj, prayer B is the interview that has already been granted by the Honorable Court. Page number 24 of my written submission. Maharaj, thereafter we see the written declaration against the public hearing conducted by the NGT, a writ of mandamus or any other appropriate writ directing the respondent number 1, which is the state, to terminate the 20-year mining lease. And another writ of declaration that the public hearing cannot have a legal sanctity or any future or prospective effect of, on any other mining projects.
What is the ad interim relief you are seeking?
Well, the ad interim relief has already been granted by this court, but it was injunction over the mining activities carried out by Hydrina Minerals, which is responding number 3 in this case. My lords, owing to the nature and gravity of these reliefs of learned tribunal or an NGT court cannot possibly grant these reliefs, which again substitutes my argument raised in issue 1. My lords, if the court is subject to any release, the council would be pleased to assist this honorable court.
Maybe in the rebuttal.
Much obliged, my lords. I would like to invite my co-counsel to take on for the continuity issue 3.
Hello, I'm counsel for the petitioner appearing for the civil rights advocates here. In this case, I will be arguing issue 3, my lords. Issue 3 deals with whether the approval granted to Hydrina meets requirements under the EI notification, PESA, FRA, and the constitutional mandates. Because I would like to bring you to page number 19 of my memorial. Now, the petitioner submitted
Again a query to you.
Yes, ma'am.
Same query which we put to your counsel. Is the entity not the best forum to answer these queries?
Well, as my co-counsel also was agreeable with the same fact. Article 25 and 26 of the people of the Maroha tribe and the people who are in the Tankikota platform. Well, it is considered to be a place of worship. Well, saying that it is my place of worship and going to the entity with the same plea under article and reaffirming my rights under Article 25, it cannot be done. The same cannot be done by the entity, but it can be done here in this case by this honorable court.
Yes.
Yes. Well, the argument which will be made by me will be in four brief submissions. Firstly, I would like to argue that there is a failure to apply the doctrine of harmonious construction. My lords, the foundational illegality lies in the state's assumption that its power to grant mining leases under the general mining laws is absolute in nature. My lords, this assumption is constitutionally impermissible. In scheduled areas, the fifth schedule, PESA, the FRA together form a constitutional code which conditions the state power. But it's the same, if I may take you page 19, I cited the judgment in para 2. In Samatha versus State of Andhra Pradesh, the Honorable Supreme Court held the alienation of land in scheduled areas for mining purposes defeats the constitutional objective of preserving tribal autonomy and self-governance. Well, if not for that land, these tribal people are being taken in isolation. They are being taken away from all the procedures that is happening. Same under the EI notification allowance. They have not been provided any translation. This is the if this is not a violation of their fundamental rights, what can it be? And furthermore, I would like to argue that the Gram Sabha, in this case, the same in Odisha Mining Corporation versus Ministry of Environment and Forest, whereas the Apex Court categorically held that the Gram Sabha is the final authority to determine whether mining infringes religious, the word religious and cultural forest rights act under the FRA Act. Well, if not for this, what else do the petitioners have, my lords? I would like to move on to the second issue, my lords, is that I would like to cite the legal maxim of lex specialis erogat generali, my lords. Special statutes have to be taken into consideration and they must prevail over the general laws. In this case, which is the general mining laws under the MMDR. But the same is flowing from the error that PESA and FRA were unlawfully subordinated to the general mining laws. But PESA is a special rights conferring statute traceable to Article 224 related to the Fifth Schedule. Furthermore, sections 4D, 4I, and 4L mandate prior Gram Sabha consultation and recommendation before the grant of such a mining lease, even for a notified mineral miner. I would just like to cite the section of PESA. Under section 4, no, this is by FRM. Section 4M, while endowing panchayats in the scheduled areas with powers and authority as may be necessary to enable them to function as institutions of self-governance, a state legislature shall ensure that the panchayats at the appropriate level at the Gram Sabha are endowed specifically with the point 3 in subsection M, the power to prevent alienation of land in a scheduled area and to take appropriate action to restore any unlawfully alienated land of the scheduled tribe.
Where you are?
Section 4 M3 of the PESA Act. 4 M3 of the PESA Act, my lords. Furthermore, my lords, the MMDR is an act for classification and control of the minerals. PESA is a democratic control and for consent in the scheduled area. Yet the state proceeded to auction and lease grant without any valid Gram Sabha recommendation and without settlement of the forest rights. This same court in Odisha Mining Corporation made it explicit that FRA compliance and the Gram Sabha certification must precede the forest diversion measures. Furthermore, I would like to go on to issue 3, the third limb of my issue, my lords, is that the public hearing, my lords. But if the public hearing is not a nullity, what can it be called? My lords, my rights were curtailed. I was not given a translator through which I can prove my dissent, my lords. My lords, I would just like to cite the factual matrix as well. My lords, during the para 11 of the same factual matrix, during the public hearing, a heavy police presence, point to be noted here. Why was there a requirement of a police presence wherein there are people of a scheduled tribe? Of what harm can they do to such a big company who is inquiring and confirming, and the state as well? Whereas the state and the company are hand in glove in this case. Furthermore, in the same line, the limited participation and only 20 citizens were permitted. 15 villagers opposed the project, voicing their concerns in Marupi. They dissented in their own language. They were not even provided the translator by the state. They did not have a voice. They spoke, but they did not have a voice. This is bound, and this is further clarified in the judgment of Utkarsh Mandal versus Union of India. If you come to page 21, my lords, of my memorial, the 10th paragraph, the bottom line, in Utkarsh Mandal versus Union of India, the Delhi High Court held that public hearings conducted without making project information accessible in the local language and the vernacular language are a total sham, my lords. And this fails to satisfy the entire legislative intent behind the EIA. Furthermore, as argued by my co-counsel members, the same thing which happened in Adivasi Mazdoor Kisan Ekta Sangathan versus Ministry of Environment and Forest. Now, if this hearing is not a nullity in nature, what can it be? Nor was I allowed to speak, nor could I understand what is happening to the people around me. But furthermore, I would like to cite the judgment of Hanuman Lakshman Aroskar versus Union of India, further reiterating that environmental clearance must reflect meaningful public engagement. But how can a public engagement be meaningful if I am surrounded by police? Why not? I would like to make an illustration of the same and say that if I am an advocate doing the same case and I am surrounded by police presence, is that not something which would fear if I say something wrong, if I do something wrong? Or there is a fear in the minds of the petitioners here. They are in fear for their lives at the same point. How can they dissent? Furthermore, there is violation of the public trust doctrine. This is the fourth limb of my argument. Article 21. This approval itself is further vitiated by violation of the public trust doctrine. This public trust doctrine forms an integral part of the Indian environmental jurisprudence. The same under this doctrine, the state holds the natural resources in trust for present and future generations. And the same is a constitutional obligation. It's a constitutional obligation which is upon the respondent in this case. The same was held in, if you see page 22 of my memorial. In Common Cause versus Union of India, the Supreme Court held that the mining carried out in violation of statutory mandates is illegal ab initio, and economic justification cannot legitimize foundational illegality. The court further clarified that post facto approvals cannot cure violations arising from non-compliance with the mandatory environmental and forest safeguards. These principles are directly applying to this case as well. If a public hearing was conducted wherein I was not allowed to speak, if the land which I believe is my place of worship is just being knocked down and seen as a normal hill, my lords, in this case. Furthermore, I would like to take you to para 10 of the same factual matrix. Para 10 of the factual matrix, my lords. Yet the environmental assessment impact report, a crucial document outlining risks and mitigation measures, was available only in English. This is the point which was argued by my co-counsel already. But I would like to put attention to the next line, lodged at the district forest. One of the respondent hearing will argue the same, that they have followed all the prerequisites, my lords. But there is no accessibility for the petitioners in the same case. How can the petitioners even dissent again, even if it is given to us, if it is lodged at some distinct forest, my lords? Now, coming to other issues, my lords, I would like to argue that the same, and the fact is, if there is a violation of my constitutional rights, my lords, the same cannot be simply enforced by the NGT. and under the writ jurisdiction of the of the High Courts, the same can be affirmed here. That is why the petitioners lie before this court, my lords.
Yeah. Absolutely. You have set out, the colleague has also set out the precautionary principles and judgments relating to that. What about sustainable development? What about employment? What about development of the region?
Indeed, my lords, I declare to consideration. My lords, to answer this, sustainable development at the cost of the rights of the tribal. My lords, sustainable development should be seen hand in hand with the rights of the tribal people. Here in this case, the respondents are trying to trample the rights of the petitioner. Well, if there was transparency in the same procedure, I would argue that okay, maybe there is a better case made out before the NGT. But the same cannot be here because there is no transparency. There is no communication. The same simply cannot fall under the doctrine of sustainable development, even though seen by the many judicial precedents by the Supreme Court and the High Court. Sustainable development at the cost of the right to have a right to have a fair environment, right to life, right to health, and furthermore, the fact is, if there is a communication made, now, if there is, let us assume the communication is made. If there is no communication to us, how do we understand what is being developed around? Whereas the respondents do not even bother to say that they will not touch the part of the hill. They simply say that bauxite is a notified mineral and we would like to mine it. Whereas if this is not an attempt to trample my rights under Article 25 and 26, what else can it be? And to further conclude,
Yeah.
in light of the foregoing submissions, the petitioners respectfully submit that the impugned approvals suffer from substantive non-compliance with statutory and constitutional framework governing the scheduled area. Now, this in the end will be a scheduled area. Those people, the tribal people, have been living in this game for multiple years, generations perhaps, generations. To say that, oh, it is the correct place for sustainable development and let us have an industry there, let us have the mining conduct. Perhaps what after mining? If the mining is conducted, let us assume the mining is conducted for around 30 years. What will that place be after 30 years?
Reasons for 20 years.
Perhaps it is just an assumption. 20 years. What will be of that place after 20 years? The same has been desecrated. My religious rights have been desecrated. So, in the light of the foregoing submissions, I would like to get to the prayer. If Malos have any other questions. Okay.
Your colleague has taken us to the prayer.
Indeed, so if does my lord require me? My lord, I'll take 2 seconds.
Yes.
My lord, the first prayer, prayer A, is to allow the repetition, and prayer B has been already granted by the Honorable Court. Prayer C is to issue a writ of declaration declaring that the NGT's dismissal of the erstwhile plea is void in nature. My lord, we are seeking the writ of declaration to have a binding and precedential effect on any prospective or potential mining in the same plateau. Whereas the third prayer is to issue a writ of mandamus or any other appropriate writ order direction directing respondent number 1 to terminate the 20-year mining. My lords are already aware of this. My lords, it is pertinent to note that we seek quashment of the mining lease and not the mere environmental clearances. We seek quashment of the mining lease itself.
Yes.
Yes, ma'am. Yes, ma'am.
Yes, thank you.
Lordship, may I approach the line?
Yes, yes.
Your Lordship, I am arguing on behalf of the respondents, and I am arguing on behalf of the respondents. Your Lordship, this whole case revolves only around 2 questions. First is the maintainability aspect,
where I demonstrate how this petition does not even deserve to be heard. Second is there are no statutory and fundamental right violations. My lord, I will be dealing with issue 1 and issue 2, and issue 3 will be dealt by my learned. Issue 1 is that whether this court is a correct forum to decide on a petition considering the prior proceedings done before the NG. My lord, the petitioner here not just have one, not even two, but three alternate remedies, which all are statutory remedies. My lord, the petitioner approached NGT challenging a statutory public hearing. NGT said that your matter is premature and they dismissed the petition. NGT never heard them on the merits. Their first remedy which they have is to reapproach the NGT under section 60 of the NGT Act. This section says that if environment clearance is given or rejected, the individual can approach the NGT and challenge the same, which they are very well empowered to approach NGT under section 60. Second remedy which they have is to appeal directly to the Supreme Court, which is given in section 22 of the NGT Act, which states that if an individual is affected by an order, award, or decision, they can approach the Supreme Court and get themselves free. The third remedy is given in section 19F of the NGT Act, which states of the review application. If the petitioners are aggrieved by NGT's premature order, they can simply apply before the NGT for a review and get themselves satisfied with that decision. My lord, the petitioners here have invoked certain fundamental rights, like Article 21 and 25, 26. Lordships are very well aware.
What do you want to say about hearing being given to them? No proper hearing being given to them.
Lordship, the petitioner major contains that no proper hearing was conducted, coercive environment was there because of presence of police, no draft PI was given in the vernacular language. All these things are some which are being placed on record by them. This is still a disputed fact. Now, High Court being the court which declares the law and not decides on fact in the writ jurisdiction, NGT is very well empowered by the Parliament to decide on such factual matters because it is the court of first instance to deal with the environmental matters. So they were very well empowered because what NGT ordered is premature. That means we cannot hear the matter now, we approach at a later stage. Rather than approaching at a later stage, they straight away approach this court filing a 226 petition. Now, there are two things which have happened after that dismissal. First is grant of EC, and second, FC was given to the Hydrina Minerals. Now, these things, NGT never had an opportunity to hear on this aspect. So, they are here first time putting some facts which the respondents are not aware of because trial has not taken place.
Are you willing to give them hearing now?
Yes, Your Lordship. The procedural defect which has been happened or being pointed out is something which the EAC, according to the EIA notification 2006, there are two authorities. First is the EAC and second is the central government. And NGT is the third authority to decide that grant of EC is valid or invalid. They approached NGT at the first stage when the application was pending before EAC.
That we know. You did not provide anything in the local language. How are the local Maori people to understand?
Your Lordship, the contention here placed by the respondent that these all allegations needs to be satisfied or be conclusive by a trial court, which is the NGT, because it has been given all powers of a civil court by the Parliament. It can very well issue notice, draw the summons orders, and can place evidences.
These are local people,
Yes, Your Lordship.
right? Their religious rights have been affected. Immediately, their religious rights have been affected.
Yes, Your Lordship.
If you ask them to go back to NGT, again the whole thing will start there.
The matter is anyway stayed by this
You give them a right of hearing, and then you give them liberty to approach the NGT. You must give them a right to hear. What is this? No hearing is given, how they will agitate their rights?
According to the
The
fact sheet,
translation has not been given. Some 15 people came there, some rule. 50 villages opposed the person. 20 people spoke. And then there was police bandobast. So there is no opposition.
According to the EI notification 2006, the Gram Sabha or the local villagers are only being called upon to get their concerns on record. The EIA never points out or never says that the Gram Sabha or the local villagers have a veto power. That means if they say no,
It's saying veto power.
yes.
We are saying they have to be heard.
Let's see the fact sheet
How many
says,
villages are there, you tell us, in the village? How many villages are there?
so the fact sheet is silent on that.
Then you have to tell us at least more than 20 at least. When you are going to give jobs to 15,000 people, there has to be more than 15,000 people that use your common sense.
I know the industry is already present in that area. The industry is expanding by taking out the high grade bauxite mineral which has been
That
found.
is all right. But people are hearing these are aspects of environment. And there are rules they have provided there. You must give people hearing. Without hearing, you can't. So many judgments have been cited by your other side.
If hearing is the only problem, I not with the
And
respondents.
this appears to us just prima facie, a sham, total sham hearing.
Your Lordship, the hearing was not flawed, and this will be very well satisfied under the amendment in issue number 2. That, may I continue with the issue 2?
Yes.
Issue 2 is that whether NGT's dismissal of the community's plea as premature was legally justified or not. My lords, NGT, while dismissing this petition, was absolutely justified. Reason being that NGT is not the first, not second, but the third authority to deal with the same EC grant or refusal of that EC. According to EIA, there is one EAC, that is Environment Appraisal Committee. This committee has power to study the documents given by the project proponent, that is Hydrina Minerals. It has power to review the video photography which is being conducted during that meeting is being going on. Then it has power to either accept or reject that application. Suppose that EC has been, the EAC is conducting its proceeding on that application. Petitioners approached the NGT and argued that these are the faulty measures taken in the public meeting. Suppose the NGT goes on issuing notice, summons, and everything, and in middle of the proceedings, EAC dismisses the grant of EC. The whole wastage of time which will be caused of the NGT. Considering this, NGT was completely justified in stating it to be premature, just because the cause of action was not crystallized. Second, my lords, let's
You will be
say,
right on that aspect. That aspect you will be right.
second thing, my lords, if the proceedings are going simultaneously, that means NGT is also hearing it and EAC is also hearing it. If the EAC founds any procedural defaults, it has power under that 2006 notification
Yes.
to call the project proponent and get things clarified which are the prima facie defect according to that committee. This is again a reason for dismissing it as a premature.
Yes.
I not say please refer to the highlighted part of that NG of that 2006 notification.
Yes. Which one?
Stick it out.
There was public consultation.
Public consultation and the stage 4 of EAC appraisal committee.
That means
Para 7.4.
yes.
So according to that para 7.4, my lords, EAC is the first authority and central government is the second authority. Now the power which central government has is if EAC grants, it has to send some recommendation to the central government. Now central government here again applies its mind on that same documents and the same things which EAC has done. After application of mind, central government is the final authority or the final say to say that whether this EC is valid or invalid. These are the two justifications which the NGT has been, the NGT had in its mind before ordering the prematurity. My lords, I would like to call my
Yes, yes. You can. Do you want to see that?
There are certain precedents, my lords, which the petitioner would like to cite for the first investigation.
Petitioner.
The respondent would like to cite certain.
the bench purpose.
Right.
My lord, the first judgment, I would like to invite my lord's attention to Jaipur Shahar Hindu Vikas Samiti versus State of Rajasthan. This is a 2014 judgment delivered by Justice N.G. Ramanathan. My lord, may please refer to page 37, the last page. It is written, when their interest can be protected and controversies or the dispute can be adjudicated by a mechanism created under a particular statute, the parties should be relegated to the appropriate forum instead of entertaining the writ petition filed as PIF. My lord, the NGT has given certain appellate provisions, certain remedies to satisfy their relief. Instead of exhausting those, they have straightaway invoked writ jurisdiction of this court. The second judgment, Your Lordship, is of Tarn Singh Nakmal
What according
versus.
to you should have been done if they were not given a hearing? What according to you should have been done by them if they were not given a hearing? Proper hearing, rather.
Government had the authority to either grant or refuse. Let's say the government gave them the EC, which has been given. Now, the only remedy for them is to approach the NGT because NGT is a court which is consisting of specialized body to deal with all this because of a special member present in it. After this, NGT is given all power of civil court, so the judgment is also binding. NGT being such a tribunal which can hear the matter for the tribal community and also can order the private party, which is the hydrogen, to cancel the project as it is. So there is no need to invoke writ jurisdiction of this court.
So according to you, there is equally efficacious remedy available.
Yes, Your Lordship. Since there is an equally efficacious alternate remedy present, this court should not invoke, this should not entertain the petition or even maintain. Lords, I would like to call my learned friend for issue 3.
My lord's permission to approach the My lords, I appear on behalf of the respondents. As my learned friend pointed out, this present petition revolves only around two questions. The maintainability aspect was dealt by him, as how my learned opponents never afforded the NGT an opportunity. The allegations which they are raising here were never heard by the NGT in the first place. I will be dealing with the second aspect, that how this EIA notification 2006 was followed word for word, how there are no statutory and no fundamental right violations. My learned opponents have challenged several aspects of the procedure. They have challenged the mining lease, they have challenged the EC granted, the FC, the consent, and fundamental rights. I'll be dealing with them one by one. My lords, first and foremost, I would like to proceed with the EIA notification. There was a public meeting conducted. 20 people were allowed to speak, and there was as per them, without any prejudice to what my learned friend says, these are still mere allegations which we absolutely deny, and first need to be settled by a fact-finding court of first instance, that is the NGT. My lord, even considering all that, there is no violation, and I shall demonstrate it right now. I shall convince my lords as to how. They have attacked the grant of EC majorly on 4 grounds. Firstly, there was no translation of the EIA draft. Secondly, it was conducted in a coercive environment. Thirdly, there was non-disclosure of the summary of meetings. And fourthly, people were not allowed to speak. I shall first convince my lords on the non-translation point. My lords, that as per the facts, the draft EIA report was not provided to the Gram Sabha. My lords, I submit that it was not a matter of choice, but it was absolutely impossible for the union to have provided them the draft copy in the Marohi language. I will convince my lords as to how. My lords, kindly refer My lords, kindly refer to the Constitution of India. My lords, the first note, official language, and the eighth schedule, my lords. My lords, the eighth schedule to the Constitution contains 22 official languages, and all the work, all the conduct of business of the union and the state functions within them. Now, my lord, this is Marathi language that we are talking about. A dialect, a language or a dialect belonging to a small tribal population living in a excluded fifth or sixth schedule areas. The primary characteristic of a fifth or sixth schedule area is exclusion for the normal society. That is the entire purpose for which these areas were secluded. My lord, these communities might not even have an official script. It could be a mere dialect, something which is known only to them. My lords, how? I pose this a question to myself, my lords. How is the union or the state government expected to get their hands on the script if it doesn't exist in the first place? But however, my lords, as an officer of this court, it is my responsibility to place before you even those points which are against me. On such a mere technical ground, something as important as public consultation cannot be ignored, especially when you are talking about a tribal area. My lord, even if the documents were not in their vernacular language, they had absolute knowledge. The company and the state ensured that they had absolute knowledge of the contents. My lords, I would like you to refer to the AI notification that we have just.
Question asked by the other judge.
Yes, my lords.
How you are saying they were in knowledge?
Apologies, my lords.
How are you saying that the local community
Yes.
had knowledge?
Absolutely. Allow me to convince you. Allow me to convince my lords. My lords, kindly refer to Appendix 4 of EIA notification, the one which I just provided. The note which says no quorum, my lords. So, Appendix 4, Para 6. After Appendix 4 deals with the procedure of the public consultation, like what exactly is to be done and how is it to be done. Para 6.1, my lords, of Appendix 4, a person authorized by the applicant company, the project proponent, shall read out the contents of the EIA notification and relevant documents to the villagers in their vernacular language. My lords, I would like to point out here that 20 people were allowed to speak. 15 said no, 5 said yes. My lords, if they did not understand what was written in the documents, then how were they even able to form an opinion in the first place? I pose this as a question to myself, my lords. Posing this as a question to myself. They were able to understand the content there because a person authorized by the company explained it to them. And the only reason being that we didn't, my lords, these are official documents we are talking about. How are the documents to be translated in a language for which the script does not exist? There must be hundreds, thousands of such languages. How can the center get their hands on them? But my lord, still, we did not leave it as a mere procedure. We have substantially complied with the intent, the purpose of a public consultation. Secondly, my lords, regarding the coercive environment, that there was a lot of police presence there.
Why?
Allow me to convince, my lords. Allow me to convince. My lord, as per para 7 of the proposition, when the para 9, apologies, my lords, para 9 of the proposition, my lords, the Maroha community repeatedly warned authorities and company representatives that mining would destroy their perennial rivers, desecrate deities, and force mass displacement from homes and villages. Peaceful protests and appeals by villagers were met with increased state hostility. Local leaders were being arrested. Multiple villagers faced criminal charges, and offers of jobs and compensation were being angled to break community spirit. My lords, when the contractors of Hydrina and the survey teams, as per the EI notification, entered upon their land, they protested. In that protest, there were certain hostilities due to which the authorities had to be called, and certain of their peoples, local leaders, were being arrested.
Our question is not whether today is not whether the arrest was right or wrong. But my lords, I would like to pose a question to myself once again. We are sending our state officials, the SPCB or the UTPCC, which actually conducts the public hearing, reasonably maybe 3 to 4 officials, and the company. We are sending those people in an area of tribals. So, as my learned opponents and even my lords pointed out, there would be over 15,000 people. So, in a crowd of 15,000 people whose sentiments are just hurt due to their local leaders being arrested, we are sending our local state officials. We are sending our officials. My lords, I pose a question to myself: is this not the responsibility of the state to ensure the safety of the company and the officials? My lords, that area is already hostile. It is a high tension area. My lords, the union and the state are absolutely competent under section 149 and 152 conditional of the BNSS 2023 conditional orders. The union and the state are very well capable to provide police protection in areas of disturbance. My lords, we have just exercised our competence to ensure that such protests, such violent situations do not happen again. Had they attacked our officials, then again we would have to initiate certain proceedings. And the entire idea, entire purpose would have defeated right there. From an environmental matter, it would have then escalated into a criminal matter. Thirdly, my lords, kindly refer para 4. Presiding officer of the public consultation.
Para 4 of?
The appendix 4, the notification. Para 4 of the appendix 4 of EI notification 2006. Presiding officer. The meeting shall be presided by either a district judge, a district magistrate, a deputy superintendent of police, or some person having eminent rank. As per para 5, the entire proceeding is to be recorded in video camera. So all these formalities, my lord, all these procedural things were undertaken. The entire proceeding is in a video recording. And my lord, this was then forwarded to the expert appraisal committee as per para 7.4, which my learned friend just pointed out. From there, it went to the central government. My lord, this project has been under scrutiny twice. First time the expert appraisal committee, and second the central government, and then it has approved. My lord, if my learned opponents still want to challenge the validity, it should be done by an authority who has the right to hear appeals against such matters. My lords, kindly refer to section 16 of the NGT. It expressly says NGT shall act as the court of appeal against either the grant or refusal to grant EC. As my learned friend reasonably showed, that whenever statutory appellate mechanisms exist, alternate remedies exist, high courts and supreme courts ordinarily suffer from using their writ jurisdiction. Second, my lords, my learned friends have also placed great reliance on the Samata judgment. However, I would like to point out that no copy has been presented to neither to us or to the judge. However, that will not be a hurdle to us. I would like to invite my lord's attention to the landmark case of Samata versus State of Andhra Pradesh, authored by Justice Ramaswamy of the Supreme Court in the year 1997. My lords.
You are kind enough to give them a copy.
My lords, kindly refer to the. If my lords permit me, within 10 seconds I will explain the facts here.
No, you can take some more seconds also.
Oblige. My lords, in this case, the challenge was that in the state of Andhra Pradesh, the center had granted mining lease to a non-tribal company, a non-tribal entity being a corporate player, to the land belonging in a tribal area. However, my lords, under para 5 of the 5th schedule, the governor is empowered to frame laws. One of the things he is empowered to legislate is upon alienation, prohibition on alienation and transfer of land. My lord, Samata did not hold that no land in a tribal area can be transferred to a non-tribal. It merely held that. My lords, kindly refer to the sticky notes validity of the regulation. It specifically mentions here that the challenge is to the Andhra Pradesh Land Transfer Regulation of 1959, which the governor had framed under para 5 schedule. My lord, Samata, this is a judgment which should be distinguished on the facts itself. Unless my learned opponents can show that there exists a similar law made by the governor of state of Varuna, this cannot be a ground to hold them. Further, my lord, they challenge the mining lease on the ground that it is contrary to the provisions of PESA and FR. My lords, I would like to draw your attention to a few provisions of PESA. My lords, kindly refer to section 4K of the PESA. My lords, mining leases. The Gram Sabha shall be consulted before granting a mining lease in a tribal area for minor minerals. My lords, this is a perfect example of balancing. Central law MMDRA deals with the government's power to regulate mining leases throughout the territory. However, PESA and FRA deal with the rights of tribals in tribal areas. That is specifically why PESA mentions a prohibition that with respect to minor minerals, no lease can be given. However, my lords, we are here talking about bauxite. Bauxite, as per the MMDRA, is not a minor mineral. Minor minerals are restricted to stones, gravels, all those things which are required for the tribals, which the tribals need for their survival. Other than that provision, my lord, there is no absolute veto. Further, I would like to proceed with the points of fundamental right violation. My learned opponents have placed great reliance on constitutional articles, particularly Article 21, 25, and 26. My lords, I would like to point out certain things here. My learned opponents have no justification as to why these fundamental rights are being violated. Coming to Article 21, my lords, as my learned friend rightly mentioned, no fundamental right is absolute in nature. Every fundamental right is subjected to reasonable restriction, and the reasonable restriction to Article 21 is the procedure established by law. My lords, the EI notification that I just cited, that was the procedure meant to reasonably restrict the rights under Article 21. And that was conducted, my lords. EI notification was followed. The NGT is created that particular matter. My lords, for not every violation of statutory procedure, you cannot invoke fundamental rights. My lords, if I have to explain with the help of a very simple example, just for the purpose of simplifying things. My lords, if there is a theft tomorrow at my house, my remedy will be to approach the police station. I will not approach the High Court filing a 226 petition saying that my Article 14 is violated. Why did the thief just steal in my house? Why not everybody else's? He is depriving me of 21 and 300. My remedy will be the police station under my house, madam. For a very simplifying purposes. You are arguing that procedure was not followed as per the EIA notification. Your rights under PESA and FRA are being curtailed. These are statutory rights, my lord. These are not fundamental rights. They have also placed great reliance on the OMC judgment. Again, since it's not provided, it won't be a hurdle. I would like to invite my lord's attention to the landmark case of Orissa Mining Corporation versus Ministry of Environment and Forest, authored by Justice Radhakrishnan of the Supreme Court in the year 2013. My lords, kindly consider the no veto banner. All that was held in this judgment is that the Gram Sabha, the local panchayats, shall have the authority to settle their rights. Nowhere does it deal with the interplay between mining lease, mining operations, and the other allied activities. There is no power of veto, my lords. If my lords would be kind enough to refer to the EIA notification for one last time, in the entire procedure, there is no mandate that you need to hear these many people. Petitioners raised the point that only 20 people were heard. My lords, again I pose a question to myself. There are around 15,000 people in the village. Are the petitioners expecting that we sit all 15,000 in line? Ask one person. What exactly is his remedy? Is a grievance. Person one will say my religious rights are being violated. Okay, that is accepted. That is noted down. Secondly, he will say my cultural rights violated. Accepted.
Continue.
Few more. Third person will again say my religious rights being violated. Fourth will say my religious rights being violated. My lords, for practical purposes, the Gram Sabha, which was meant to be a participative democracy on the in the villages, can one person not just hear the views of all the people and convey them to the company? What is important here is that the concerns of the people should reach the company, and the company is then supposed to apply its mind.
Council, who do you act for? Who's your client?
My lords, here we are representing the state, the center, and the company.
You're representing the state. State is expected to be fair to its citizens.
Absolutely, my lords.
So state doesn't have to argue as if you are appearing for the corporation who has got the mining lease.
Absolutely, I understand. But since those points were raised here, a challenge was also made to the mining lease. And the EC, all the judgment my lords will deliver today will also affect the rights of the corporation. Therefore, it's important even they should be. That's all.
The council for the state does not argue for the corporation.
Absolutely.
Yeah.
That was the structure. If my lord want to consider that was the advocate for the state and I am for the corporation.
No, we will not.
That's right.
We are considering that you are taking care of the interest of the corporation.
And,
And that is the allegation.
absolutely. Good morning. My lords, further, if I can make one last point.
Please conclude in your- conclude in your
Yes, yes.
how you want to conclude.
MMDR. Is the MMDR with my lord?
Yes,
Yes. My lords, kindly see the alternative remedy para. Even under the MMDRA, if the matter is being challenged to the mining lease, which as my learned friend rightfully mentioned, is not within the jurisdiction of the NGT, even under MMDRA Act, they have remedies. Under Section 30 of the MMDRA, the central government has revision powers. Under 30A, special courts are established. Under 30B, those courts have powers of session courts. They have sufficient alternative remedies in every case. But just to invoke the jurisdiction of my lord's court under 226, they are unreasonably treating statutory violations as fundamental right violations, merely to invoke the writ jurisdiction. My lord, they have not exhausted five of their alternate remedies, three under the NGT and two under here, two under the MMDRA. My lords, therefore, it is my humble request that their petition, if my lords are convinced, I would like to proceed with the prayers. My lords, in light of the arguments raised, issues advanced, and pleading cited, the respondents humbly submit that their petition should be dismissed at the maintainability stage itself, and the interim stay that was granted on the mining activities be vacated. It was a pleasure arguing before you.
Well, it's proceeding with the reporter. There were mainly 3 to 4 alternative statutory remedies which were enunciated by our government. One of them which were Section 60 of the NGT Act. Well, it was sufficiently admitted by both of my learned friends that the present matter has not been delved into the merits and has not been heard for any other time. Hence, while if that is the case, then how can we possibly approach the appellate jurisdiction of any court if the first time the merits of the matter have not been dealt and settled in? Hence, while Section 16 is not a bar. Additionally, my lords, referring to the clarification that the committee provided with respect to the facts of the case, there was no liberty granted by the National Green Tribunal to reapproach the trial after the tribunal dismissed the plea as premature. Same applies to the prerogative and the purview of Section 19F, my lords. Further, my lords, another assertion raised by my learned friends that there is no veto power to the poor citizens of the Maravi community. But with that, I would like to invite your kind attention to paragraph number 5 of our Moot proposition, where the factum here is deemed to be absolute and non-disputed. Well, it reads that the Honorable Supreme Court of Aurelia has delivered some landmark judgments, such as Ratiraj versus State of Indira, Ziverva Hills versus Union of Aurelia, and has reinforced that no mining can occur in scheduled areas without prior and informed consent. And local Gram Sabha, a bedrock principle for ensuring participatory democracy and preservation of cultures. Hence, my lord, the question whether we have a veto or not is kept aside. And just by the dictum of this, it is clear and there is no iota of doubt that our informed consent is one of the prerequisites to even begin with the mining. Further, my lords, 30-second explanation. Further, my lords, as Appendix 4 has sufficiently read about the vernacular aspects, indeed accepted that there are only 22 official languages listed, and this language is also a part of a dialect. But my lords, translation is an onus that falls upon proponents. Moving forward, my lords, the learned friend assessed that 20 people out of 15,000 were enough. This contention was already dealt with me. Another assertion raised was that this is a hostile and high tension area. My lords, I failed to read which fact disclosed this assertion over here. There is not a single fact which states that this is a hostile area. To the absolute contrary, my lords, on page, paragraph number 8 of the factual matrix discloses that the entry of Hydrina's contractors, trucks, and survey teams, my lords, survey teams, this includes the engineers of the proponent's team, entered the village, conducted their surveys, and went. My lords, the apprehension that they justify that it is a hostile and high tension area without any factor on the first place. Were these contractors ever harmed? What did we do to repel? Peaceful protest. And secondly, my lords, the other two statutory remedies, which was being purported to me as a statutory remedy, the EAC committee, my lords, the EAC committee concludes to a recommendation. It has no judicial power. How can I go before the committee? The only judicial power rests with the NGT in this particular case. With that, my lords, I would like to wrap up my remarks. If my lords may permit one more rebuttal, one last additional rebuttal with regards to a precedent cited, my lords. Much obliged, my lords. Orissa mining, my lords, the very page and the very part highlighted by my learned friends over here, which was provided to us. Owing to their gracious gratitude, my lords, I would like to read paragraph number 63 and 64. Religious freedom granted to STs under Article 25 and 26 of the Constitution is intended to be a guide to a community of life and social demands. The above-mentioned article guarantees them to the right to practice and propagate not only matters of faith and belief, but all those rituals and observations which are regarded as integral part of their religion. The right to worship the deity Niyam Raja therefore has to be protected and preserved. My lords, the attempt to read a judgment in isolation cannot be done and cannot be used to yield a favorable result over here. With that, my lord, I would like to rest my case.
The respondent seek permission to leave it. No. Well, just on a few points. He raised certain points. No.
You already performed very well.
These were additionally raised. That oblige my
Already.
Thank you.